Hi, I'm Daniel Gregory. I've been asked to speak briefly about certain matters related to construction law in Colorado. And specifically, what I wanted to talk about was construction defect litigation as it affects people who buy interest in real property, whether it be a condominium or a single family home. One of the first things everybody should understand is that in Colorado, no lawsuit or arbitration can be brought until the party bringing the claim, the owner of the property, first complies with something called the Construction Defect Action Reform Act, which the shorthand term is SDARA. Under SDARA, before you bring a claim against any construction professional, any developer, any contractor, subcontractor, architect, or engineer, you must first send them written notice of the claim and list the defects and how you think your property has been damaged from that. Once they receive this notice, they then have 30 days to come out and inspect the property and see what their evaluation is. They then have another 30 days on residential projects or 45 days on commercial projects to offer a solution. The solution can be a monetary settlement, it can be work, it can be some combination of that. The owner who sent the claim then has 15 days to respond or to not respond. It's only at the end of that process that an action or an arbitration for construction defects can be brought against somebody. People who start to do repair work or try and file a lawsuit before that process get stopped and have to go back to start and go all over again. One of the most important things about this SDARA notice of claim and list of defects is that under Colorado law, it actually triggers the obligation of the defending party, let's say the contractor or the developer's insurer, to come in and offer a defense to start to get involved in the project. So in previous times, somebody had to actually file a lawsuit to get the insurer of the other party involved. In Colorado now, by sending the SDARA notice, if there's anything in there that might be covered under the contractor, developer, or subcontractor's insurance policy, the insurance company has to get involved. And getting the insurance company involved sooner than later is what leads to getting a result sooner than later. So it's very important to understand that before you bring any sort of claim in Colorado involving construction defects, you must first go through the SDARA process. A qualified attorney is the best person to help shepherd you through that process and make sure it's done correctly. The other thing that any owner of real property or any potential owner of real property should probably know are the types of projects and the nature of claims that are most likely to be subject to a construction defect action. Nobody wants to be involved in a lawsuit, but you'd like to know sort of what your risk level is. And in Colorado, in terms of the type of project, the projects that are most prone to any type of construction litigation claim are multifamily projects, primarily condominiums or large subdivisions created by a single developer. The next most likely project are high-end single-family homes, and the third most likely project would be a commercial project, an office building, a sewer treatment plant, or whatever. If you're buying, therefore, into a condominium or subdivision, it's very important to look at the CC&Rs, the covenants, conditions, and restrictions, or the declaration, and determine how any construction defect claim that might befall the common areas of that development or condominium are going to be managed. Are they all regulated simply by the board? Do the owners get involved and determine whether or not to hire a counsel? Is there a certain percentage of owners? Similarly, when you're purchasing a single-family home, you want to look at the purchase documents. Do they limit you to a specific type of claim? You might be routed only to arbitration versus litigation. You might have a certain time period to bring a claim. So those are important things to understand when you're buying any type of real estate. If something goes wrong, what's the remedy and who really is going to be involved in determining what that remedy is? In terms of the nature of claims that we see most likely in construction defect law, I would say the single largest one are claims having to do with soils, either subsiding or swelling, and effects on foundations. Because of course when the foundation for a home or a condominium project or a sewer treatment plant starts to go, it affects everything above it. So foundation settlement, soils issues are probably the single biggest issue. The next one that I would rank is probably issues having to do with water penetration through roofs, through windows, through improper cladding. And then maybe the third are other types of structural concerns, such as not putting in correct load-bearing walls or not having the foundation built correctly, even though the soils are good. So those are things to, in particular, when you're buying real estate, to look at. Are there any issues with the foundation? Are there any issues with the roof? Have there been any water penetration issues? And also, as I mentioned, make sure that you understand that whatever the controlling documents are, what their remedy is, and who's going to be in control of determining that remedy if, in fact, a claim needs to be brought.